Special Committee on Maritime and Admiralty Zones is hereby called to order. Since this is just a continuation of a suspended hearing, there is no need for an appropriate quorum here. We'd like to recognize the resource persons present here. Secretary, can you acknowledge them again for the record,
Yes, Mr. Chairman.
including those virtually present?
Yes, Mr. Chairman. Good afternoon, everybody. Representing the Department of National Defense, we have Mr. Jesse M. Pascasio, Executive Assistant under the Office of the Undersecretary for Strategic Assessment and Planning. We also have physically present with us is Solicitor General Minardo I. Guevara. Afternoon, sir. Representing the National Security Council, we have National Security Specialist 4, Ms. Donalyn M. Dolina. We also have Deputy Director General Nestor C. Jerico. From the National Intelligence Coordinating Agency, we have Deputy Director General Restituto Santos. Afternoon, sir. From the Philippine Navy, we have Rear Admiral Cesar Bernard N. Valencia.
Good afternoon, sir.
From the Philippine Coast Guard, we have Captain Nelson J. Timbang.
Good afternoon, sir.
Coast Guard Captain Donet Dolina.
Good afternoon, sir.
And Coast Guard Commander J.T. Tariela.
Good afternoon, sir.
From the University of the Philippines Institute for Maritime Affairs and Law of the Sea, we have Attorney J. Batong Bakal.
Good afternoon, sir.
With him is Attorney Neil Simon S. Silva. Attending virtually also from the same institute is Attorney Jacqueline Espinilla. Attending virtually with us from the Australian National Centre on Ocean Resources and Security, Dr. Stuart Kay.
Good afternoon.
Good afternoon, Professor.
That is all, Your Honor. Thank you.
Thank you. Before we discuss lengthily the bills under consideration, and we have 1, 2, 3, 4, 5, 6, 7, 8 pending measures on the proposed Maritime Zones Act. May I get a 2-minute statement coming from the Philippine Coast Guard to satisfy the curiosity of our viewers and listeners as well? What is the relevance of the pending measures with the incident that transpired yesterday? Will it help? Will it clarify? Will it dilute the confusion? Will it foster more amicable situations insofar as the Coast Guard is concerned? Anybody from the Coast Guard? Yun nangyari kahapon?
Thank you, Mr. Chair. On the part of the Philippine Coast Guard, sir, I think the passage of the maritime zones would help the Philippine Coast Guard as a law enforcement agency and the armed forces of the Philippines in clearly identifying the maritime zones of the Philippines. With respect with the incident that happened in Ayungin Shoal, which falls within the exclusive economic zone of our country, I think the passage of a maritime zone would clearly strengthen our defined zones in our maritime jurisdiction, sir.
Will it enable other states to follow international norms and standards as a form of an obligation under existing international customary laws? Will it enable them to adhere? Will it force them to follow if we pass this maritime zone law? Will it force adherence and compliance, making it obligatory for them to respect not just our territory, but maritime safety as well.
Mr. Chair, I would like to believe that the countries in the region and other claimant states in the South China Sea, which all of them are signatory to the United Nations Convention of the Law of the Sea, are in the obligation to respect our maritime jurisdiction if ever we're going to define our maritime zones. But of course, that's a belief that we would like to carry on. But obviously, there are some states who would choose not to respect the provisions of the international law, particularly the UNCLOS. So I don't want to be that pessimistic to argue that all of the countries would respect our maritime zones, even if we're going to pass our own maritime zone, sir.
Thank you, Coast Guard. Can we have another opinion just to edify this committee coming from the Office of the Solicitor General? If this law is passed, would it in the same question? It's like the final question in a beauty pageant. The same question is being asked. You just covered the ears of the finalists to really vet the correct answer. But here, everybody's listening. Kung maipapasa po ba itong batas na ito, ay mababawasan yung tensyon sa West Philippine Sea.
Good afternoon,
Good afternoon,
Senator
Project.
Tolentino. Based on my reading of the proposed bills on the Philippine maritime zones, immediately it occurs to me that this is essentially a reflection of the relevant provisions of the UNCLOS, to which more than 100 countries are members. And therefore, if we have a law like this, which is essentially a reflection of an international convention where the members comprise practically the entire international community, there is an expectation, Mr. Chairperson, Senator Tolentino, of an obligation on the part of these member states to comply with our own laws, since these are, as I said, a reflection essentially of an international convention of which they are members.
So what you're saying, Solicitor General, is that if this bill is passed into a law, we would be expecting other state signatories to UNCLOS to respect the same.
That is very true, because this will be our domestic version of an international agreement. And these are the laws of the coastal state. And therefore, all flag states with vessels plying, for example, our maritime waters, would have also a duty to comply with the laws enacted by the coastal state, like the Philippines.
Thank you. And perhaps you would just consider it very coincidental that we scheduled the hearing not knowing in advance that an incident would happen yesterday. Thank you. Having heard those statements, I think it is more proper for us to really tackle the bill, all the bills, including the controversial provisions, provision by provision, para po madali po itong matapos. Ang nakikita ko lang pong contentious provisions would be those reflective of the definition of archipelagic waters, the provision on reciprocity, the provision on exclusive economic zone, and that's about it. That's about it. Unless others would be in a contrary position. So this is what we are going to do. We will be asking the opinion, not just the official position papers of the resource persons present here, but their preferred hubris of how the law should be shaped. So we will be asking, these are more legal and academic. So perhaps if the resource persons present here physically would allow, we will be asking first our resource person who is out of the country. Isa lang siya, no? Isa lang siya, Professor K. Uh, just one, question, and I think you gave a different opinion concerning. You raised three matters. You raised you raised an issue concerning. I know. I think it is Professor Beckman. Professor K, were you the one who raised the issue concerning reciprocity?
Yes, Your Honor, I did.
Yes. So your contention is that the provision on reciprocity should not be included in the measure. Is that correct?
Certainly, Senator. I would take the view that the strength the Philippines draws in being able to respond to other states in the manner that the Coast Guard and the Honourable Solicitor General have mentioned is the consistency of the legislation with international law. Reciprocity invites a different approach where you would be saying, well, if there is a breach by somebody, then we reserve the right to provide for a similar breach. And I'd caution against that. I think the strength the Philippines has had in its dealings with other states, the support that it received from other states in the wake of the famous arbitration that you had, stemmed from the Philippines' compliance with international law. I know that other viewpoints were raised, and certainly there was one suggested by my friend and colleague, Professor Batong Bakal, saying perhaps this would be a matter that the legislation could reserve to the President to determine. Not being a constitutional lawyer or admitted in the Philippines, I'm happy to defer to his suggestion in this regard. But I do think that the Philippines draws great strength from its consistency with norms of international law, and the reciprocity provision would potentially undermine that objective. I'm sorry, I've lost all sound at this end. And so if there was a question directed to me, I apologise, Senator. I didn't hear any of it at all. I'm sorry, I have no sound.
Thank you. My question is reciprocity now a recognized principle as part of customary international law? To your knowledge, Professor.
Certainly, Senator, the concept of reciprocity exists principally in a trade context. It isn't unknown in international law. I'm not sure that it would assist, as I say, in the Philippines' efforts to draw international support, which was the thrust. I'm not suggesting that reciprocity itself is unknown, but only that it would be a measure that would not assist in drawing additional support to the Philippines and its international legal position.
What I'm referring to, Professor, broadly is the concept of reciprocity that probably would encompass international trade, diplomatic privileges and immunities, human rights, extradition, etc., etc. So, is this a well accepted concept?
Yes, certainly, Senator. Reciprocity does exist.
Yes. So,
It,
yeah, go ahead.
it involves basically responding to a breach by denying some privilege to the other side, which, if it was done independently, would amount to a breach itself. This is why the concept effectively is a breach for breach, which is why I wouldn't encourage it, because the Philippines' strength has been through close compliance with the law of the sea.
So, but if it is not breach for breach, it is not similar to your an eye for an eye. So but what is needed under international law is that it has to be commensurate to a
That's
wrongdoing. Correct?
That's
Is that
correct.
Correct.
And
So,
certainly that's the context in particularly international trade law where the concept is most commonly used.
it has to be proportionate to the wrongdoing done by another state. Is that correct?
Absolutely. That's correct.
So the question now here is, do we need to legislate reciprocity? If it is a well accepted principle under international law.
I wouldn't like to speak to constitutionally how these arrangements go. I know that in responding to this issue, Professor Batong Bakal suggested that this would be a matter that the President would have the power to deal with. If that's so, then legislation specifically dealing with the matter wouldn't be necessary if it's part of the President's executive functions.
So what you're saying is that perhaps because it operates as an underlying principle or a customary practice in international relations, there is no need for domestic legislation. For instance, if a state would not issue a visa to a citizen of another country, that other country can also refuse to issue a visa to that other state, refusing to issue a visa to its own national. Is that correct?
Yes, that's correct, although the refusal to issue a visa wouldn't itself be a breach of international law.
Yes, that's right. But what I'm saying is this, there are certain international norms and practices that need not be legislated.
Certainly, that would be a perfectly reasonable proposition.
And would you say that the maritime zone bills section, I think do you have a copy, sir, of the proposed measure? I'm holding a copy here of a measure which was approved by the House. The rights and privilege, I'm reading it now, section 12. The rights and privileges of foreign vessels and aircrafts in the Philippine maritime zones declared herein are recognized under conditions of reciprocity and mutual respect. Do we have to legislate mutual respect?
I don't believe so, Senator. No, I wouldn't think it was necessary.
There was an issue raised by the Department of Justice concerning countermeasures. Countermeasures, perhaps the representative from the Department of Justice can refresh our memory. What was that again, ma'am?
Yes, good afternoon, Mr. Chair and everyone. During our last meeting, I did mention about countermeasures in relation to this concept of reciprocity in Section 12 of our pending Senate bills. And this is already what you are discussing, Mr. Chair, with Professor Stuart K. It's that when a state endures or acts inconsistently with international law, thereby injuring your rights, you can take action. Because you have been injured, you can take action against that other state. And this is in relation to the nature of the international legal system, wherein there is no court with compulsory jurisdiction and there's no world police. So if there's no court with compulsory jurisdiction and no world police, then how can you get remedy, Mr. Chair, if you have been injured by another state? So you can take countermeasure. First, you can demand that the other state stop the action, the illegal action that it is doing. If it doesn't stop, then you can take countermeasure against that other state. And your countermeasure, of course, must be proportionate with the injury or with the action that caused the injury to you, and your own countermeasure must not involve the use of force, because use of force is not allowed under international law. So that's it, Mr. Chair. Countermeasure: if you are injured, then you can take action also against another state that injured your rights as provided by international law.
The position of the Department of Justice that we should include reciprocity because there is a need for countermeasure. There is a need. There is a need for flexibility on the part of the executive branch to impose countermeasures.
Yes, that's correct, Mr. Chair. Even without this provision, I stated during our hearings 2 hearings ago that even without this provision, Mr. Chair, the president, as part of his foreign relation powers, can actually take countermeasures. But we defer to the wisdom of the body if Congress would also like to provide a statement in its own law as a form of lawfare, wherein that if another state is committing an action inconsistently with UNCLOS, thereby injuring your rights, don't you have the right to take action against that other state as a form of countermeasure, so long as that countermeasure does not involve the use of force? You're allowed that, Mr. Chair, under international law. So it's a congressional statement in its own law. The president, without this provision, can take countermeasures. But if the Congress would also like to have a statement in their own law of that particular principle, it's not illegal, Mr. Chair.
So what you're saying, Attorney Ganchon, is that there is no need to explicitly include Section 12 because a countermeasure, the ability to respond can be understood as a general manifestation of one's sovereignty. There is an inherent and supreme authority recognized by international law for a state or country to take control over its territory, population, to effectively govern. And there is no need for the president to be granted that power because the president has that power, and his executive functions protecting the sovereignty of the country. Correct? Madam.
Yes, I agree with what you've stated, Mr. Chair. Let us imagine the international community. All members of the international community are sovereign states. All are equals. If one equal committed a wrongful act against you, since all of you are equal, wouldn't you be able to have the right to also take countermeasure against that other state? So Without this provision, yes, the president can take countermeasures. But if Congress would also like to have its own statement on reciprocity and countermeasures, it can do so. It's not illegal. If you remember, Mr. Chair, during our first hearing, Professor K mentioned that it's actually a question uh, of implementation. It might be difficult to implement. No? If you have a vessel there of a state, and you need to determine first if the flag state of that vessel has previously committed an act inconsistent with international law. Because if you take a look at Section 12, it says that the flag state of that vessel must, if the flag state of that vessel acted inconsistently with UNCLOS, so it's not just an action inconsistent with general international law, it should be an action that is inconsistent with UNCLOS. We all know, the one thing that we're not talking here is, we all know who this state is acting inconsistently with UNCLOS. We all know who this state is. It's not any other state, actually. No, when I believe when this provision was drafted, we're thinking of a particular state acting inconsistently with UNCLOS. So I think that's the reason behind this provision, Mr. Chair. But if you take this out, it's okay. But actually, it can also be placed, Mr. Chair, in the archipelagic sea lanes law, because actually what we are concerned of is the passage of foreign warships in archipelagic waters by warships of foreign states that are acting inconsistently with UNCLOS, especially in the West Philippine Sea. So we don't like the vessels or warships of this foreign state acting inconsistently with UNCLOS to pass through our archipelagic waters. So if you don't place it here, you can place it in the archipelagic sea lanes law, or you can totally take it out, Mr. Chair. All three options are legal, Mr. Chair. There's nothing illegal with retaining it, removing it, or transferring it to another law. If we retain it here, Mr. Chair, we just need to revise it to take into consideration the comments that we have received so far from our experts, local and foreign, Mr. Chair. Thank you, Mr. Chair.
Thank you, Attorney. Professor K, from the discussions right now, what is probably the point of convergence is this: a countermeasure is needed to provide a sort of self-help for wrongful acts made by another state to another state, to induce the responsible state for that wrongful act to cease the wrongful act and to go back into the state of compliance. And the recent incident yesterday probably would illustrate this. Our Coast Guard was hit by a Chinese militia vessel. Our resupply ship was hit on the port side by a Chinese Coast Guard vessel. So in terms of countermeasures, the international law would not espouse the use of force, but would support the notion of commensurate, proportional countermeasures. We're now skipping a bit Section 12 without putting you into a controversial position. What countermeasures would you probably suggest that should be done? Would it be a diplomatic countermeasure? Would it be an economic measure? Could it be some trade restriction? Among others. Professor K, we are listening.
Certainly, Senator, there'd be a range of responses. I would think that diplomatic would be the one that the Philippines has enjoyed some success with in recent years, and quite a number of states have been happy to stand with the Philippines in responding to incidents, as well as statements that have been made that have been at variance with international law. So to that extent, I think it would be good. Certainly, international law does not permit the arrest of vessels which are sovereign immune. So if a Coast Guard vessel undertakes behaviour that's inconsistent with your law, international law will not permit you to arrest that vessel because of the nature of the vessel itself. And this was reaffirmed relatively recently in a case between Argentina and Ghana, where the Ghanaian Supreme Court ordered the arrest of an Argentinian naval training ship. So a response that involves arrest or of that nature would not be possible. It would be a very significant breach of international law. But diplomatic and potentially other restrictions in terms of refusing to issue visas or responses of that nature are certainly within the power of the Philippines to do, and might be effective in expressing your concern as to the unacceptable nature of behaviours like those that I've read of that have happened in the last 24 hours.
Thank you, Professor. Attorney Batumbacal, any words of wisdom?
Yes. Yes, Your Honor. Thank you for this
We're
opportunity.
referring now to Section 12
Yes, Your Honor.
in relation to what happened yesterday.
Yes, Your Honor. The provision on reciprocity and mutual respect is actually one that I've advocated, and I was the one who actually introduced the original draft of this. And the reason for this is, well, actually it's more for domestic purposes, really, national purposes, because one thing that we have noticed, even within the national context, is that people often tend to need a specific reference in law, a specific provision, a specific textual basis to justify actions, especially if such actions might be controversial. And that is the concern here with respect to the maritime zone law, is that we are actually complying with our obligations under UNCLOS, but certain states will not and can abuse it. For example, the state that Attorney Ganchon is referring to is of particular interest because I can think of two possibilities already. One is that they will, for example, invoke the right of archipelagic sea lanes passage through archipelagic waters when they pass through Philippine waters. But as soon as we try to pass through waters that they claim to be theirs, they will say that, no, you cannot pass through these waters. And particularly, we're referring to naval vessels, military vessels. And that would be an abuse, basically, of the rights and privileges that we recognize that they have in our waters, but they will not reciprocally recognize our rights in their waters. The other one is with respect to baselines. Okay, we have established archipelagic baselines. These are in accordance with international law, with UNCLOS, but they also don't necessarily come with some burdens because that's the result of the compromise we agreed to. That compromise requires other states to also respect our rights to establish such baselines and to act in accordance with our laws. But this other country has established its own baselines, which they are now trying to project as archipelagic also, but they claim rights within those waters in excess of what UNCLOS allows. And they would try to establish these baselines around the island groups that they claim in the South China Sea. The Spratly Islands, for example, they will claim that those are internal waters, not archipelagic waters, notwithstanding the fact that they are trying to present them supposedly as archipelagic baselines. So that is another way by which they will abuse these concepts. And I do not want, basically, our government in the future to be somewhat hesitant, no? Because we know that this other state will say that, look, your own law does not allow you, does not say anything about you taking such actions against states which exercise their rights and privileges under UNCLOS. So I do not want a situation where our own laws will be used against us simply by the mere silence of those provisions. So this particular provision is actually declaratory as well as much as providing options. Mutuality and mutual respect are basic concepts even in contract law. And that is, especially in a situation where you have an international community where, as Attorney Ganchon mentioned, no, there is no third party that can enforce or no third party with power over the sovereign state. It really depends on, in a way, self-restraint of all states. Self-restraint in that they will follow what it is that they agreed upon. And we have a problem with a state which does not follow what it has agreed upon. So I would want to emphasize that, no, that particular prevention of reciprocity and mutual respect as a kind of declaration. No? And then the second part is the one that reserves the right of action to the executive very clearly. It will provide the executive in the future a clear legislative mandate and basis to take action if it is necessary. No? It is still subject to their discretion after all, but the statement of that reservation of that power, I think, is very important to ensure that the intention of this Congress in enacting this maritime zone law is not, is not subject to some kind of loophole or gap due to silence on certain matters. So that is really why I put it there, Mr. Chair. The other concern that I have is with respect to our exclusive economic zone and continental shelf, where we have every right to explore and exploit for petroleum resources. And due to the looming energy
Before we
shortage.
proceed with the other sections,
Yes, sir.
perhaps I'll be asking Professor Kay and Attorney Ganchon again. Your preference a while ago was, Attorney Ganchon, was to have this placed in the archipelagic sea lanes law. Is that correct?
Just one of the options,
One of
Mr.
the
Chair, because the
options.
department actually defers to the wisdom of Congress. The
Yes.
department says you have these options.
Yes.
You can retain. But if you retain it, you revise it based on the comments here by our experts, local and foreign, or you can delete it, or you can transfer it to the archipelagic sea lanes law. But of course, if you transfer it, Mr. Chair, to the archipelagic sea lanes law, it would be limited only to violation of UNCLOS committed in our archipelagic waters. Here, it's a violation of UNCLOS with respect to our maritime zones, all of our maritime zones, territorial sea, contiguous zone, exclusive economic zone, and continental shelves. In such a way, it's a broader provision, Mr. Chair. So all of those options one can take, and we defer, Mr. Chair, to the wisdom of Congress. If, as stated by Professor J. Batong Bakal, if you want to also include in your law a statement that the President can actually take this action, okay, you can do so, Mr. Chair, because Professor J said the mere silence in the law might.
Isn't it the non-mention of the presidential powers would not necessitate the defanging, the diminution of the powers of the presidency? Kanya naman talaga yung powers na yun eh. By mentioning the powers, would it actually restrain, because you're now putting a parameter, because that's his power as the chief architect of foreign affairs, as the commander-in-chief. That's part of his array and menu of powers. So do we have to enumerate all the powers that the president has at his disposal? Certainly not. So he has the diplomatic tools, all part of his toolkit, diplomatic, economic, military, etc., etc. It's all there for his own use. Perhaps, Professor Kay, can you elaborate further on the hardship that probably would be felt during the operationalization of this provision? Is it administratively hard for the government to implement this? There was a mention before, which I forgot, about the difficulty in making this operational. There is reciprocity provision. You have the floor.
Thank you, Senator. Look, the provisions that were featured in a number of the bills indicated that reciprocity was possible where another state provided for breach. That suggested to me that there might be a requirement to assess where breaches existed in order that the executive could frame what reciprocity might include, and that could be quite onerous as well. If it's based around the flag of a vessel, that can be undermined by other vessels being utilised. So, for example, a state may not flag a vessel, but may have beneficial ownership in the vessel or control of it, or it might be controlled by nationals of that particular state, in which case they can avoid the nature of the provision. My own country has had problems with this in the past where vessels have been flagged in places such as Tuvalu, but they're under the direct control of the government of North Korea. And in those circumstances, a provision that was directed towards flag wouldn't have any meaningful effect because Tuvalu isn't the problem in this instance. It's the North Koreans directing what the vessel did. In these circumstances, I'd counsel towards giving the executive the ability to be able to measure what might be an appropriate response, because then it can be tailored to a particular issue and measured against that issue, as opposed to something that might have a potentially wider ambit if expressed in legislation. And that was the point I was trying to draw out with my initial comments at the hearing before last that I attended.
So the underlying principle is to give the president that great flexibility in responding to a situation without being limited by a specific provision, because the buzzword that you just mentioned would quote unquote is onerous. It's similar to our tax code here in the Philippines and even the federal Internal Revenue Code of the United States, wherein the commissioner of Internal Revenue is given that broad power to change some rates, tariff rates, etc., etc. So, are you saying that the president has that power, and that the president the presidential power should not be limited by a specific provision because he has that broad power and should be given enough elbow room to respond? Is that the correct rationale for this?
Essentially, Senator, yes, although I must stress that I'm not a constitutional lawyer qualified in the Philippines, but you've expressed my concern quite neatly.
Solicitor General, any word on this, sir?
Mr. Chair, we're still on the topic of reciprocity.
Yes, Section 12.
Mr. Chair, the matters of reciprocity and what was mentioned earlier on countermeasures seem to me to be very related to each other. To me, it seems that reciprocity will be more on the positive side and countermeasures on the negative side. So we're talking about reciprocity in the sense that if certain states are not granting the privileges that we are extending to them, then we have the right to deprive them of the same privileges. So it's mutuality. And I think that is an accepted principle under international law. So it's just a matter of, it's something for the Congress to really decide on whether to include something like that or not in the maritime zone bills. But I do not see any disadvantage if we have something like that. A provision, a general provision on reciprocity and mutual respect. However, on the negative side of putting a provision on countermeasures, as you correctly pointed out, this is something that the executive, the chief executive, can actually perform because this is the nature of executive power. So I'd rather not have something like that in the draft bill, but have a provision, a general provision on reciprocity and mutual respect.
Thank you. Perhaps we can jump on to the other concerns. The definition of archipelagic waters. This probably would be a provision that would have to be discussed lengthily, as well as the implications of the 2016 arbitral ruling. May we ask again the statements coming from Professor Batumbacal? Do we have the same bill in front of us? I have here the approved House bill. Seven eight one nine. if I can go ahead, archipelagic waters is defined under Section 5 of the measures approved by the House. So within the paragraph 2, within the archipelagic waters, closing lines for the delineation of internal waters shall be drawn pursuant to Article 50 of the UNCLOS and other existing laws and treaties. Thereafter, the Philippines exercises sovereignty and jurisdiction over its archipelagic waters and airspace, over it as well as its seabed and subsoil in accordance with the UNCLOS and other existing laws and treaties. Professor Batumbakal.
Yes, Your Honor. This, I think, is the most compact way in which we can legislate essentially the implementation of Part 4 of UNCLOS, which is comprised of many more articles. So this is really a general statement that allows us to do so, Your Honor.
What about the implications of the arbitral ruling? Should we make any reference or explicitly include the 2016 arbitral rulings implications on the archipelagic waters?
Well, Your
Any
Honor,
reference?
well, with respect to the South China Sea Arbitration Award, there is already a general reference to it for that covers the entire bill. So I do not see really any need to restate it here. Also, the South China Sea Arbitration Award, most of it really concerns the exclusive economic zone and continental shelf outside of the archipelagic waters. So they would be much more relevant with respect to the EEZ and continental shelf provisions. And I think that's why we did not have to do it here in the archipelagic waters provisions.
Response concerning Article 5.
Thank you, Mr. Chair. Yes,
Do we have the same bill?
yes,
In front of us, yes.
yes. You're looking at the House bill, Mr. Chair. Yes, and in fact, your own bill, Mr. Chair, is identical to this House bill. So, with respect to archipelagic waters, the language here is consistent with the pertinent provisions of UNCLOS, Mr. Chair. We don't need to make a statement in Section 5 with respect to the arbitral award, because the arbitral award actually did not really tackle archipelagic waters. Well, it did mention about archipelagic baselines around Spratly Islands, but it did not really rule on archipelagic waters. It ruled on our exclusive economic zone in the West Philippine Sea, that we have an exclusive economic zone there, and that the 9-dash line of China, which encroaches on our exclusive economic zone, is a blatant violation of UNCLOS and international law. And Mr. Chair, if you take a look at Section 10 of this bill, Mr. Chair, which is also identical to your Senate bill, the arbitral award is already mentioned in Section 10 entitled Adherence to Existing Laws. So there's a statement there that the other rights of the Philippines relative to its maritime zones and entitlements shall be exercised in accordance with UNCLOS, the awards rendered by the arbitral tribunal in the Permanent Court of Arbitration case number 2013-19 in the matter of the South China Sea arbitration between the Republic of the Philippines and the People's Republic of China.
Do we really have to throw this question back? I'm sorry. Do we really have to insert the name of the parties here, or do we just cite the case itself? Because it might, if we legislate the title of the case, the citation, it probably would years from now connote a different or promote a different branch of history. What I'm saying is, looking forward, perhaps the goal of international law is to really promote friendship and amity. But if you really would carve out any reference to an opposing party here, would it promote enduring, lasting F, or do we really need to have that scar? We will win. We have won Do we really want to have that scar as part of our legislation?
Mr. Chair, it's a matter of style, Mr. Chair, but this is, I confirm that this is the correct full name of the case. If you take a look at page 1 of that case, Mr. Chair, this is the full name in the matter.
We will not try to
the South
revive
China
history years ahead, but
arbitration.
what we're framing right now is that that the Solicitor General mentioned the word positive. Would it be a positive legal term to include? Matter of style, I agree.
It's a matter of style. You can say 2016 South China Sea Arbitral Award, Mr. Chair. And in fact, Mr. Chair, we noted in our study of this bill that it says awards, no? It's plural because there's actually 2 awards issued by the Arbitral Tribunal. The first award is the award on jurisdiction and admissibility issued on October 29, 2015. And the second one is the award on the merits issued on July 12, 2016. So if you want to be very accurate and if you want to refer to awards, then you need to insert here the date October 29, 2015, because that's the first award issued by the tribunal.
And who
Mr.
knows, there might be other awards.
Yes, but it would not be the same PCA case number 2013-19. Might not be the same, Mr. Chair. So we're just referring here to PCA case number 2013-19, and there are 2 awards issued by the tribunal under this PCA case number, Mr. Chair.
Thank you. A matter of style, perhaps. Solicitor General, I saw you nodding your head or shaking your head. Matter of style as to
Yeah, it's a matter of style.
Section 10, but
Yeah, it's a matter of style.
really we're on archipelagic waters, so reference was made to Section 10, but perhaps I skipped this, the Section 2 definition of maritime zones would probably need more refinement insofar as phraseology would be concerned. So Section 2 has no reference to our Constitution. Section 2 has no reference to UNCLOS. Section 2 has no reference to the baselines. Professor Batumbakal, can you enlighten us on this?
Yes, Your Honor. Yes, I think this again, Section 2 was an attempt to encapsulate the coverage really of the Philippines, national territories and maritime zones. No, so that is, I think that's the reason for the economical nature of the provisions. No, but I recognize you're correct, Mr. Chair, that mention of the Constitution, UNCLOS, and the different categories of the Philippine national territory under Constitution are not there. So if the chair would indulge, I did come up with a possible more detailed formulation that covers the chair's concerns.
Professor, you can submit that to the committee, but you can
Yes, sir.
you can read a portion of that because what we're crafting is a maritime zone law, and we have a very abbreviated definition of maritime zones. So what is the meaning of maritime zone? Is it by virtue of our existing constitutional precept of our territory coming from the Treaty of Paris? Is it based on UNCLOS? Is it based on the just cited arbitral ruling? Or is it a combination of all? Because our constitution and even the deliberations during the Constitutional Commission made mention, and I made mention of not just, and this is cited by the case of Magallona versus Ermita. The definition, the deletion of the words historic right or legal title should not be interpreted as precluding future claims over which the Philippines does not actually exercise sovereignty. So, baka po may mga pagkakataon pa na lumaki pa ho yung ating teritoryo. So kung nilagay na natin dito sa maritime zone na ito lang yung ating teritoryo, eh baka sumalungat naman tayo dito sa Magallona versus Ermita na sinasabi that it should not preclude us from actually exercising future claims. Balay nyo, balang araw, mas malakas yung sandatahang lakas natin. Tayo na yun ang babangga. Baka mas marami na tayong mapuntahang territory. I'm not referring to a claim somewhere in the south which might arouse different interpretations, pero Magallona versus Ermita decided by the Supreme Court is very clear. It should not preclude us from exercising future claims to areas over which the Philippines does not actually, and that would mean the present situation, does not actually exercise sovereignty. Professor Batumbakal?
Yes, Mr. Chair, you're correct. No? That's why it's always been a dilemma of balancing, shall we say, the wording. As currently worded, Section 2 is very general. Yes, that might be a disadvantage to some in that it doesn't specify, and there would be doubts as to where it applies to. But then, on the other hand, it can also be interpreted to apply at any time now, because when you say the maritime zones of the Philippines, there is no specification of what that word the Philippines actually covers. So that can be used, for example, to refer to the Philippines as it exists now, or the Philippines as it exists in the future, like 50 years later, if any configuration has changed, it would still be applicable.
Po tinanong yan kasi si Attorney Gatchalian kanina ay binanggit at laging binabanggit yung pangalan ng yung title ng case dun sa arbitral ruling. So yung sa arbitral ruling sinabi ito yung atin. Subalit itong ating Supreme Court sinasabi ito Magallona versus Ermita, ito pa yung pwedeng maging atin. And yet we are not mentioning the Philippine Supreme Court in our measure. Hindi natin binabanggit yung whatever the court will decide pursuant to the Magallona versus Ermita. So, nakatali tayo doon sa arbitral ruling. Ito yung sinabi ng International Court, pero yung ating sariling kataas-tasang hukuman, sinasabi, pwede pa pala tayong lumaki. Pwede pa lumaki yung Pilipinas, di ba? How do you reconcile the two? The arbitral ruling as well as if this is an obiter, the pronouncement coming from Magallona versus Ermita, that perhaps in the future, sinabi ni Attorney Batumbakal, 50 years from now, baka tayo pa lumaki, baka may mapuntahan pa tayong iba. I'm sorry, Professor K, I'm speaking in our language. What I'm saying is this: we're trying to reconcile the arbitral ruling as well as a decision coming from the Philippine Supreme Court, which recognizes that perhaps in the future, the Philippines can actually exercise claim and jurisdiction over areas not being claimed right now. So it's part of decisions of the Philippine Supreme Court would form part of the laws of our land. So there is a need to reconcile this, and I leave it. I will. That's the reason why I'm asking our experts here in front of me. Again, Professor Batumbakal, you have the floor.
Thank you, Mr. Chair. Well, basically, we just need to make a kind of decision whether the verbal formula that we will use basically is one that is open to interpretation even decades from now and would still be applicable to the situation decades from now, or if we want a verbal formulation which is specific and using only using contemporary references. So I think this is something that we will have to defer to the wisdom of the Congress about. But for me personally, my preference would be for more general wording, so that no matter what kind of changes there are, they can still be covered, no, the Section 2 will still apply to them regardless.
So you're not espousing the mention of the arbitral ruling. You're not supporting the proposition that the UNCLOS should likewise be mentioned in Section 2, as well as reference to the normal baselines that would probably include the Kalayaan Island Group as well as Baho de Masinloc.
Well,
Hindi na natin yun. Hindi na
well,
natin.
not in this specific provision, Your Honor, because if it's in this provision, then the other provisions will also need to reflect the same kind of formula. Mention of those matters can be better off in a separate provision, a general provision, like as it exists, similar to what exists now in the current version, where it's a separate section 10. That way, it's there. It can apply to all the preceding sections, and at the same time, if later on things change, it can be separable. No? Subsequent legislation perhaps can adjust it simply by referring to that specific provision. No, but at least we don't need to amend each and every one of the other provisions of the law.
So what you're saying, Professor, is that a separate provision after Section 10, which would make mention of the archipelagic baselines under RA 9522, as well as, what about, diretsuhin ko na to. Diretsuhin ko na to para maliwanag. Kailangan ba natin banggitin dito yung Baho de Masinloc at yung Kalayaan Island Group? Yun na yun. Hindi na tayo magpapalihis-lihis.
In Section 2, Your Honor?
Another section, as what you insinuated.
Well, it would simply reiterate RA 9522, and it would be a clarification that we are applying the maritime zones to those areas as well. So I think it would help. At the very least, it will eliminate any potential ambiguities. The other way that can be tackled, however, Your Honor, no, assuming we don't put it here, no, the other way it can be tackled is through implementing rules and regulations, actual executive action, because that would still be part of the law anyway. No? So even if we don't mention, even if the law is very general, no, in its wordings and descriptions, it will be the executive which will now bridge the gap between the law and reality through implementing rules.
There were abuses in the utilization of the IRRs. Sometimes the IRRs would not jive with the law.
True.
Sometimes the IRR can be considered as administrative legislation. So if there is a chance of having that placed here, would it be wrong?
I do not believe it would be wrong, Your Honor.
Would it be contrary to the arbitral ruling?
No, Your Honor, because RA 9522 simply enacts archipelagic baselines and then describes the separate island territories of the Philippines as being subject to normal baselines. And that's exactly what the arbitral ruling actually supports.
Would it be contrary to our constitution because of the deletion of the words historic rights or legal title?
Well, historic rights and legal title no longer appears in the current
Yes.
formulation, Your
Yes.
Honor. So I don't think it will be a violation.
Would it conform to Magallona versus Ermita?
Yes, Your Honor, because Magallona versus Ermita simply validates the enactment of RA 9522.
So sa palagay niyo po, Attorney Batumbakal, maggawa tayo ng isang section na nakalagay na po yung Kalayaan Island Group at Baho de Masinloc.
Pwede po. Pwede,
Scarborough Shoal, Panatag.
pwede po.
So that would be after section 10.
Pwede po. I can imagine it's something like an area of application or, well, it can actually be incorporated into the current version of Section 10. No?
Do we limit it to Kalayaan Island Group and Baho de Masinloc o baka hanggang saan pa ba tayo?
Well, sa ngayon
Saan pa ba tayo?
sa ngayon po, Your Honor, yun lang naman yung other areas outside of the main archipelago that we have sovereignty over.
Wala
Wala
na
namang
iba?
ibang isla anywhere in between.
Sigurado tayo doon?
Papa.
Yung Subi. Subi Reef.
Subi po is within the Calayan Island Group.
Hindi ba natin i-mention yun?
Hindi po kailangan
Hindi
dito.
na kailangan.
Opo.
Pero do we
Kasi nga
have,
po, this law
do we
is
have
more
possession
general.
of Subi? Who has possession of Subi?
China currently occupies Subi Reef, which is unfortunate for us. No?
So you are in agreement that we have another section that would make mention of the Scarborough Shoal as well as the Calayan Island Group.
Yes, Your Honor. It can be a clarificatory kind of provision.
Thank you, Professor. You've heard us, Professor Kay? We cannot hear you. Please unmute.
Yes, Senator. I've listened to the discussion with interest. I must confess, aspects of it in terms of the Philippines domestic law are outside my expertise. I don't have a significant problem with Section 2 as it proceeds in the draft at present. I think it introduces the subject matter very well. When I expressed concern some weeks ago at the initial hearing that I was invited to, my concern was to ensure that the baselines generated by Philippine territory outside of the Philippines archipelagic baselines were consistent with international law. And at the moment, Section 3 in Section 4, rather, I should say, Part B, refers to baselines outside of the archipelagic baselines drawn in accordance with Article 8. Article 8 limits you only to straight baselines pursuant to Article 7, whereas other forms of territorial sea baseline, particularly those under Article 6 that can apply to reef.
Professor, where are you now? You're in Section 6 or?
Section 4.
Section
of the
4.
bill.
Before we proceed with that, are we all in agreement as to the implications of line 2? All territories of the Philippines shall generate the respective maritime zones in accordance with international law. I'm referring now to the definition of territory.
Yeah. I have no difficulty with Section 2 as it presently is
The
drafted.
second sentence, I'm referring to the second sentence. All territories of the Philippines shall generate the respective maritime zones.
Yeah, no problem with that as it presently stands at all.
Professor Batumbakal, no controversial implication?
No, Your Honor. In fact, it's a very general statement. It gives us flexibility.
Even if the territory is not right now occupied by the Philippines,
Yes, Your Honor.
they should generate their
Yes, Your Honor.
maritime zone,
Yes, Your Honor. Our
even if it's
only
occupied by another country.
Yes, Your Honor. Our only difficulty there is that because we are because it's occupied by another country, we are unable to take the necessary step of actually measuring or determining the normal baselines because that requires people on the ground actually doing the measurements.
But would it not give them the privilege of again exercising jurisdiction of a maritime zone in a territory supposed to be ours, occupied by them, now applying the law that we're trying to craft here?
No, Your Honor, because number one, this
They
is
will
our
benefit.
no, Your Honor, because number one, this is our law, and they're not bound by it. Basically, they don't recognize it, and in fact, they are trying to apply their own law to that area. No, so it doesn't. The fact that we enact it this way does not give them that kind of authority. They cannot invoke
They
our
cannot
law
use
against
this
us.
against us.
Yes, Your Honor, they cannot use this against us because. In fact, if they invoke our law, then that means they're recognizing our sovereignty and
Correct.
jurisdiction. So,
Correct. That's what I'm alluding to. So no problem with Section 2. Professor K, you went to Section 4. You jumped ahead. Internal waters. Nothing wrong with this.
Look, I'm sorry, Your Honour. I just note that I'm jumping on a plane in about 15 minutes, so I was doing my best to be as helpful as I could with the time remaining.
Yes.
My
Go
only,
ahead with Section 4 before
Yeah.
we allow you to leave.
my only concern is that the reference to Article 8 of the Law of the Sea Convention unnecessarily constrains the Philippines' ability to use other forms of territorial sea baselines around territories outside of the archipelago. So, for example, if you have a feature like Scarborough that has an outer reef with land territory inside the atoll structure, you would want a baseline that was on the basis of the outer reef, which would be consistent with Article 6 of the Law of the Sea Convention. The reference to Article 8 limits you only to straight baselines in accordance with Article 7, which wouldn't be useful. You would be unnecessarily constraining your ability to do things that you are otherwise entitled to do. That was the point I was seeking to make.
I think you're correct. There should be no mention of Article 8 because that would, in effect, implicate likewise Article 7 of
That's
UNCLOS. So the straight baselines would be implicated, and perhaps this can be subjected to a variety of interpretations likewise.
Well,
So
it could be. Article 6 is perhaps the most useful given the geography of the West Philippine Sea, in that you would have a number of features that would be surrounded by reefs, and you would want to measure your territorial sea baseline from the outer edge of those reefs to maximise your entitlements, which international law give you. So a reference to baselines that didn't allow you to make use of that would be unnecessarily wasteful of an opportunity, if I can put it that way.
So either we delete article, the reference to Article 6, or specifically mention Article 6, delete Article 8, mention Article 6, or just drawn in accordance with the appropriate provisions of UNCLOS. Make it that general.
Yes, I think that the general approach would probably be the best. It would give you the greatest flexibility. I think really just noting the reference to Article 8 is unnecessarily constraining.
I agree.
The idea would be to have as great an opportunity as possible.
Thank you, Professor. I think you have another appointment. You're leaving. You're about to leave.
That's right, Senator. I have to jump on a plane to Yosu in South Korea. So I'm terribly sorry I can't be of greater assistance. But
you've been
if I
of
miss
great
my
assistance. You've been of great assistance. The committee will give you an appropriate certificate of appreciation.
Well, thank you very much, Your Honour. It's been a delight to assist, and I wish you and your colleagues every success.
Thank you, Professor. Professor Batubakal, any response concerning the deletion of Article 8 and placing in lieu of Article 8 appropriate provisions of UNCLOS?
That is fine with me, Your Honor. It does give us more flexibility, as Stuart has noted.
Thank you. Solicitor General, any response concerning this? Matatapos natin to.
Mr. Chairman, we submitted the OSG's position paper today.
Yes.
And
bibigay lang sa akin.
right, and we presented various options depending on the exigency of or the need for the immediate passage of the Maritime Zones Bill. So if there is some sense of urgency to enact this law or this bill into law right away, then probably we can stick to the general formulation of the various bills. They're general enough, and my understanding is that they're practically lifted from the counterpart provisions of the UNCLOS with respect to the definition of the maritime zones. Now, we can probably, we presented certain options actually, Mr. Chairman, and one of this, in our basic position paper, we mentioned that there are two significant matters that could probably be included in the Maritime Zones Bill. And that is, number one, on the Eastern Front, the matter of the Philippine rice. The grant of by the Convention on the Extension of the Continental Shelf, or rather on the Extended Continental Shelf, be mentioned because that's a very significant development in our eastern front, the eastern side. And on the western side, the arbitral award of July 2016 is something worth mentioning. So it all depends, Your Honor, on whether we need to pass this law immediately. Because if that is the case, then we can probably stick to the general formulation of most of these bills. But if time would permit, then we would suggest certain other inclusions in these proposed bills. For example, we can, as I mentioned, these two major developments is one other possible option. Another option would be to make reference to the actual existing bills, I rather laws that pertain to our rights and obligations on various maritime zones, like on the territorial sea, on the EEZ, et cetera, being incorporated in these bills. So the whole problem with that, Mr. Senator, is that will probably take a lot more time in enacting this bill if we will incorporate the relevant provisions of other existing laws. So what we're trying to do, in effect, is to update and codify all the rights and obligations pertaining to our maritime zones. So it really depends on what Congress intends to do. If Congress wants to come up with this law immediately because of current circumstances, then I guess in general, the present formulation would be sufficient. But if time would allow, then we would have wanted the inclusion of certain other.
Is your son captured?
Sorry.
Can we unmute? Technical, we have a challenge interference. Radio challenge. Go ahead, Soljan.
Well, that's about it, Mr. Chair. We're just presenting certain options. But if you're minded to, in general, adopt the more or less uniform presentation of the bills by the various proponents, then we have no further anything to add, nothing further to add, except on the matter of the west of the Benham Rise and the arbitral ruling with respect to our neighbor.
I totally agree, Soljan, that Benham rice or the Philippine rice should be included, and I think this is really very relevant insofar as the Pacific side is concerned, and the utilization of marine research and the identification of the underwater sea features, which NAMRIA, without the knowledge of Congress, did unilaterally. Alam nyo, sinasabi ng ibang mga kasama ko sa Senado, ay yung pagpapangalan nga ng kalye, inaaprubahan pa ng Senado. Ang nangyari dito, inaprubahan na, nakikinig ang NAMRIA ngayon. Ginawa na ng NAMRIA ng mga pangalan kung ano-ano yung mga hundreds of underwater features sa Benham Rise. So, this should likewise be part of the measure. Tama po yun, Soljen, and I was browsing at your position paper. You made reference to the fisheries decree, fisheries code, the NIPAS include. Siguro po, general reference to existing laws can be inserted in the bill under consideration, Section 10, or even in the Section 10, adherence to existing laws. So we totally agree. One last controversial item that probably would need the convergence of minds here is with reference to the exclusive economic zone. Exclusive economic zone, Section 8, the exclusive economic zone of the Philippines refers to the waters beyond and adjacent. This is an unclosed definition, and then mention was made of Presidential Decree 1599, otherwise known as the Philippine Exclusive Economic Zone of 1978. But this was prior to UNCLOS. This was prior to UNCLOS 3, 1978. So Is there really a need to make mention of the 1978 law? I'm referring to Section 8. Siguro pwede nang alisin yun. Valid pa ba itong Philippine Exclusive Economic Zone of 1978? Is this still a good law? This probably might be a presidential decree overtaken by events. Any Department of Justice? Bakit hindi na lang ito yung amend natin? Yung Philippine Exclusive Economic Zone of 1978. Is this still a good law?
Yes,
Wala pang UNCLOS nun eh.
yes, that's correct, Mr. Chair. This is a 1978 issuance, and it predated the 1982 UNCLOS. But the advantage, Mr. Chair, of not totally repealing Presidential Decree 1599 is to show to the world that we have actually expressly claimed our EEC way back in 1978, because under UNCLOS, you don't automatically have an exclusive economic zone. Unlike the territorial sea, which is automatic to you, we just need to declare its extent. With respect to the continental shelf is also automatic. With respect to the EEC and the contiguous zone, you need to expressly declare and claim that you have an EEZ and contiguous zone. So the advantage of mentioning this law is an acknowledgement that we have declared our EEC way back in 1978. The provisions of PD 1599, some of the provisions continue to be good law because it's based on the provisions of the UNCLOS. But there's some provisions there that are outdated already. Like, for example, it's Section 5 that provides for the imposition of the penalty of imprisonment in case of violation of our rights in the exclusive economic zone. This would already run counter to Article 73 of UNCLOS, which provides that the violation of our fisheries laws in the exclusive economic zone cannot be punished by imprisonment. We can only impose fine. But anyway, that particular Section 5 has already been considered amended by our fisheries code, which actually provide very high fines, no, in millions of pesos with respect to poaching by foreign vessels in our exclusive economic zone. And I just would like to connect this because in our position paper, in our study, Mr. Chair, you would receive it, we're actually proposing an inclusion of a section on implementing rules and regulation. But we took note of what you said, there's an abuse in the drafting of the IRR because the issuance of an IRR might actually help. We can say in this law that the concerned agencies can issue IRR, and violation of those IRR imprisonment can be imposed, for example, because in our exclusive economic zone, we have rights there, not just on fisheries. You have rights to regulate the establishment of artificial islands and installation. We have the right to regulate the conduct of marine scientific research. The concerned agencies can issue these implementing rules and regulations, and violations of those IRR can be punished by imprisonment so long as there's a provision in our bill that violation of those IRR can be punished. We consider this proposed Philippine Maritime Zones Act as actually our mini constitution on our maritime zones. If the UNCLOS is the constitution for the oceans, the Philippine Maritime Zones Act is our mini constitution for our seas. So it declares all of our maritime zones and our rights with respect to those maritime zones. The concerned agencies of the government can issue IRR to regulate the exercise of our rights in our maritime zones, Mr. Chair. So going back to PD 1599, it remains to be good law because there's an advantage in mentioning it to show to the world that we have actually expressly claimed our EEC way back in 1978. There's just a need to update some of its provisions, Mr. Chair, because the statement there on our rights are not the complete rights under UNCLOS. Thank you, Mr. Chair.
My only concern, attorney, correct me if I'm wrong, is that because this was circa 1978, this probably was made after the 1973 Constitution was promulgated. which mentioned clearly historic rights and legal title. The historic rights and legal title was deleted under the 1987 Constitution. And if we proceed further, one of the main uh, issues ruled by the arbitral tribunal was the complete disregard of historic rights, historic fishing grounds of China in areas being claimed by China. So if we now revert back to the 1978 law, would it run in conflict with the decision in Magallona versus Ermita, as well as the arbitral ruling disregarding the notion of historic fishing rights for the arbitral ruling, historic rights for the under 1987 Constitution? Will it conflict with our agreed upon previous provisions that we stick to the present legal regime? Baka naman tayo magkabulol-bulol na tayo rito. Dito, sabi nyo sa China, wala kayong historic fishing rights. Tapos ngayon, tayo naman, dito sa exclusive economic zone natin, ang basehan nito, yung historic rights din natin. Hindi kaya magkawindang-windang tayo rito?
That is correct. Your statement about historic rights, Mr. Chair. No, the arbitral award has ruled that China has no historic rights in our exclusive economic zone. The basis of our rights in our exclusive economic zone is not historic rights, but sovereign right, Mr. Chair. When we issued this 1978 presidential decree, the negotiations for UNCLOS were already underway at that time. The negotiations were concluded in 1982. It took about 10 years to conclude the negotiations. So in 1978, when we issued this law, we already have an idea of the language to use for the declaration of our exclusive economic zone. And the basis of the establishment and declaration of our exclusive economic zone is not based on historic rights, but based on sovereign rights, Mr. Chair. And that's also what is provided right now in the 1982 UNCLOS. Sovereign rights po yung basis ng EEC natin.
What
and
about
not
the
historic
1978
rights.
exclusive economic zone law?
Ito po, yung exclusive economic zone law natin is not based on historic right, but sovereign
Ano
right
provisions to anong exact words?
sa law po. I don't have, but we can
Yes,
check
I think
right
you should take a look at that because connected yan sa 1973 Constitution. Solicitor General, any word on this? Kasi kung ilalagay natin itong Presidential Decree 1599, I agree, it would show historical roots. But
Yeah.
then again, it might run counter with existing
I don't
legal
think so,
precepts.
Mr. Chair. I think Presidential Decree number 1599 was mentioned in this paragraph only in relation to the previous part of the sentence where the exclusive economic zone was determined to be up to the extent of 200 nautical miles from the baselines from which the breadth of the territorial sea is measured, comma, as established by Presidential Decree number 1599. So the mention of PD number 1599 was only for the purpose of restating the basis for the 200 nautical miles measurement of the exclusive economic zone and for no other purpose.
Thank you. Likewise, we probably would be asking a one-pager from the Department of Justice, consistent with my previous questions a while ago. So, any issues concerning the exclusive economic zone, sovereign rights for purposes of exploiting, exploring, conserving natural resources, etc., the seabed, which the DFA just entered into a treaty, the economic zone, artificial islands. Should there be a mention of islands, artificial islands, within our exclusive economic zone, constructed by another occupier? What happens to those islands? Silent na lang tayo? Atin yung lugar, may gumawa ng artificial island. Pagkatapos, ano na mangyayari daw? How do we treat them? How should the new law treat those islands? Under lease, under usufruct, ano yon? Ano mangyayari doon? Under tolerance, in perpetuity, being used by another tenant without paying rent. DOJ,
Thank you, Mr. Chair. I just checked the PD 59. We will submit in addition in our position paper. But Mr. Chair, with respect to artificial islands, the language of our bill, pending bills, Mr. Chair, in Section 8, is taken from UNCLOS itself, lifted po siya. It's lifted from UNCLOS, and one of our rights in the exclusive economic zone is the exclusive right to construct or regulate the construction of artificial islands, installations, and other structures. Yes, so we
the
don't-
artificial islands should be constructed by the state which has the sovereign right to construct. But in our case, there were artificial islands constructed by another state. What happens now to those islands?
those
It's not part
islands.
of UNCLOS. It's not part of UNCLOS. Probably this is now the time you define your countermeasure.
Yes, those islands are illegally occupied, Mr. Chair, and that
Occupied or illegally constructed?
illegally occupied, and the artificial island is illegally constructed, Mr. Chair.
How do we address this situation? How should we define them?
Yes, there is a continuing violation of our rights in the exclusive economic zone. And you're right, Mr. Chair. There's a need for a countermeasure, maybe. Yeah, because there's a continuing violation, Mr. Chair. That is a fact. No? Everybody knows that our neighbor has 7 artificial islands in our exclusive economic zone. 2 of those,
Can you name them for the record?
yes,
Can you name them?
Mr. Chair, the 7 artificial islands of China are placed on top of Mischief Reef, which we call locally as Panganiban Reef, Subi Reef, which we call locally as Samora Reef, Johnson Reef, which we call as Mabini Reef, Gavin Reef, which we call as Burgos Reef. So that's 4 already. Quarteron Reef, which we call as Calderon Reef, Fiery Cross Reef, which we call as Kagitingan Reef. One more, McKennan Reef and Huge Reef, which we call together, we consider them as one as Chigwa Reef. So 7, Mr. Chair. Let me just state for the record that 2 of
You
those.
have an A for this recitation.
Thank you, Mr. Chair. I memorize it. I'm a regular attendee of the National Task Force for the West Philippine Sea, Mr. Chair, and as an alternate representative of the DOJ. And Mr. Chair, let me just state for the record that out of the 5 artificial islands illegally occupied by China, 2 of those islands are low tide elevations. In particular, Mischief Reef and Subi Reef. Mischief Reef is just about 125 nautical miles from Palawan. Since it is a low tide elevation, it forms part of our EEZ and continental shelf, and it is not subject to appropriation by any state. It is not land territory that can be appropriated. So China placed a artificial island on top of it, about 550 hectares in size, and no matter how long China stays in that artificial island, million of years, no matter its occupation thereof, can never ripen into ownership because that low tide elevation is not the subject of appropriation. Mr. Chair, this is the same
That is
for
also
Subi Reef.
included in the arbitral ruling. But are you interested in having that included as a subsection in the artificial islands, which I mentioned a while ago?
No need, Mr. Chair.
No, not the complete citation of the islands, but illegally constructed islands, or would it be too aggressive on our part to mention that?
Let me just relate to what our Solicitor General, our former SOJ at the Department of Justice stated. We want to be positive in this law. This law is like our constitution, our mini constitution for the oceans. So it just enumerates our rights in our EEC. For example, we have the sovereign rights to construct artificial islands in our EEC. But violation of our rights, Mr. Chair, you can actually provide for penalties, Mr. Chair. But this can be done
In reparation.
in an IRR, Mr. Chair. We can issue an IRR that would regulate the construction of artificial islands in our exclusive economic zone, and violation of those rules, penalties can be imposed. So pwede po sa IRR na yon, because this is just
Would there be a difference from what you know, if an island, an artificial island is being constructed by a Filipino and a foreign, a national, would there be a difference? Not a state party. For instance, a claimant, Filipino citizen would want to convert a reef or a shoal into an artificial island as his own, as against a national of another country. There'd be a difference.
Actually, if it's a foreign national, Mr. Chair, in collaboration with Filipino,
No,
foreign national,
On his own, on his own.
on its own. It's
But
actually easier to punish a foreign national than if it's a state that constructed the island, because a state would enjoy state or sovereign immunity, isn't it, Mr. Chair?
Or if it is a Filipino citizen.
A Filipino citizen, more so, in violation of
Filipino citizens. 10 na sila.
Yes, all citizens, Filipino citizens
So-
are subject to our laws.
What
They
about a
can-
joint venture between a group of Filipino citizens and a group of foreign nationals constructing an artificial island somewhere out there in the West Philippine Sea for tourism purposes?
Yes, they can be punished if we provide a law for it, Mr. Chair, with punishment. These are private individuals. They don't have immunity.
State corporation.
State corporation. It depends. Yeah, it depends, Mr. Chair. But the thing is, now that we're talking about it, we actually don't have a law regulating the construction of artificial islands in our exclusive economic zone. So that is why, Mr. Chair, in our study,
And with the indulgence of DOJ, is Sandra Arcamo.
I'm not a lawyer, Your Honor, but then I think they will have to undergo the environmental law on environmental impact assessment. So they still have to seek certificate to do so. So I think under the environmental law, they are bound to seek how do you call this, a consent
From
from
the
the national
DNR.
government. Not only DNR, but other NGAs as well who are affected.
So back to the question again, would a provision germane to artificial islands, including the ownership, should it be included, or should just tumahimik na lang tayo?
because, Mr. Chair, it says here, Section 8B, we have the exclusive jurisdiction with regard to the establishment and use of artificial islands, installation, and structures. So if you have this general language, it means that any state that establishes an island there without our consent is violating our sovereign rights, Mr. Chair. So there's no need to also include a paragraph here on illegal construction, Mr. Chair.
Agree, Solicitor General?
Yes, Mr. Chair. Jurisdiction here implies some form of regulation on the part of the state. So it doesn't really matter whether it's a foreign national or a Filipino national who will be, let's say, engaged in the establishment or use of an artificial island. Jurisdiction would connote here some form of regulation. As mentioned earlier, for example, the regulation to conduct an environmental impact assessment and other necessary permits from the Philippine government. So I guess this will be sufficient. So if anyone who constructs without the appropriate consent or permission from the Philippine government would in fact be in violation of this paragraph B of Section 8.
But we do not have any, I don't see any penal provision here concerning violations. So we'll be referring to what?
Well, if there are other existing, for example, environmental laws that may contain or include penal provisions, and then I guess that should be applicable. Especially, we have Section 10 here, where we make reference to other existing laws in relation to this bill or law.
And would that be sufficient to include destruction of corals?
Under the Fisheries Code, I think that is already covered, Mr. Chair. Marine environment, NIPAS also.
And other regulations on maritime zones and entitlements of the Philippines and international law. Tama po ba yan? Of the Philippines and international law. Are we now just referring to the Philippines here, or are we skipping domestic legislations here that can be likewise violated? Section 10, I'm referring to Section 10. Siguro subject to style, we can still refine this. Section 10. Professor Batumbakal, any other items concerning exclusive economic zone? What about the benefits of marine research? The benefits of research and development being done by private groups, by other governments. Should the Philippines be entitled to not just partly the proceeds, but the benefit, the research itself, the technology, the knowledge, the wisdom gained
Yes,
from the research?
yes,
Should it
Your
be included here?
This one, the fact that we are,
Section B.
yes, Your Honor. The fact that we are establishing jurisdiction or declaring our jurisdiction with respect to marine scientific research and all these other areas is already a declaration that we will regulate these matters. With respect to marine scientific research, there is actually a pending proposed executive order to lay out the rules and guidance for this. I am not sure exactly what is the status now because it was proposed under the previous administration but got superseded by the election, and then it had to go through the process again under the current administration. That executive order would lay down the administrative process for marine scientific research to be conducted by foreign researching entities who wish to do research within Philippine waters.
So clause silent on this.
No, Your Honor.
The proceeds, the benefits.
No, Your Honor. With respect to monetary benefits, UNCLOS is silent. But that is because UNCLOS provides for an overall framework for the state to be able to regulate any marine scientific research done by a foreign researching entity in its own waters. And it leaves it open now. It leaves it to the discretion of the coastal state to lay down whatever conditions it wants, whenever there is such a research. So even though it's not mentioned, the Philippines, in implementation of its jurisdiction, could make those kinds of conditions. It now all depends on what type of research it is, because there is research, for example, that is purely scientific in objective, but then you also have research which has commercial implications. So different types of research, there are provisions for that. Example, petroleum exploration is a type of research, so we already have the petroleum law for that. Bioprospecting, there are existing rules for that as well. And those would refer to things like those with pharmaceutical implications. So it all depends now on the particular research area and the appropriate department or body of government that actually has the regulatory authority for those types of activities.
Would it be appropriate for this committee to include a word or two concerning commercial and or scientific medicinal benefits that can be derived from that area?
Well, Your Honor,
The proceeds would be included by implication.
well, Your Honor, marine scientific research, I think, is broad enough a term because one of the problems, even during the UNCLOS negotiations, was that they could not really, number one, come to a definition of marine scientific research, which clearly encompasses all types of research. And there were even debates as to what should be included there or not. So that's why they left it, they just left the term undefined. It now depends on each state to be the one to determine it in its own jurisdiction.
It's a gray area, and this one is related to the use of artificial islands.
Well, they can be separate, Your Honor, because these are clearly different activities. You can have marine scientific research based on artificial islands, but then again, you can also do all other sorts of things using artificial islands like defense or
Tourism. I understand there's another state
Yes, Your Honor.
using an island as a resort.
Yes, Your Honor.
As a resort. Right now.
Yes, Your Honor. And that's why it's better to sort of keep it general so that it will be up to the state to determine what will be covered in the course of its implementation. And it's open enough. No? We don't want to restrict ourselves by accidentally by putting in only a few words or having words that might have restrictive implications for our interpretation.
Professor, continental shelf, I think we don't have a problem with that. The provision on adherence to existing laws, subject to refinement. What about the recently signed treaty concerning the seabeds? Would it be implicated here? DOJ? That was signed 2 months ago.
Yes, Mr. Chair, with respect to this so-called BBNJ treaty or the agreement under the United Nations Convention on the Law of the Sea on the conservation and sustainable use of marine biologically biodiverse resources in the high seas, Mr. Chair. Since it governs this marine genetic resources in the high seas, we don't have jurisdiction to pass a law with respect to those marine genetic resources on the high seas, Mr. Chair.
It's not related. Kasi yung prolongation, connected yun.
Yes, the prolongation, Mr. Chair, that's the natural prolongation of our land territory under the sea. We call it the continental shelf. And on the eastern side of the archipelago, we have an extended continental shelf mentioned by the Solicitor General, the Philippine rice. And so it's a different legal regime, Mr. Chair, governing the continental shelf. For MGR, marine genetic resources, it's more on the resources themselves existing in the high seas or in the international seabed area, Mr. Chair, which is not under the jurisdiction of any state. It's considered as that area is considered, for example, as the common heritage of mankind, the
correct.
international seabed area. And of course, the high seas are subject to the freedom of the high seas and open to the enjoyment of all states, Mr. Chair.
So we've tackled a lot. I just want to recognize and ask the contributions coming from the other resource persons present here. And then thereafter, we will be convening a select technical working group to really refine this after November 6, to enable Congress the Senate after the passage of the General Appropriations Act to tackle this measure, because this is part of the LEDAC priority bills espoused by the President. So as to the urgency mentioned by the Solicitor General a while ago, I think this is urgent. This is urgent not just because of what happened yesterday. This is urgent because it's needed. This was needed 5 years ago, 10 years ago, or 15 years ago. So we have to pass this, but the inclusion of the Philippine rice is imperative. The definition of the exclusive economic zone would need refinement. The notion of reciprocity, I will have to consult with my colleagues. The delimitations would stay as it is part of UNCLOS. The mention of, I think if we really are to be general and would want a framework on this, the mention of specific laws would have to be deleted. Like for example, the Mining Act here of 1995 is included under Section 9. Kailangan ba talaga itong ilagay na natin dito, yung Philippine Mining Act, which is about to be amended, or maraming pagbabago to? Kailangan ba natin ilagay ito sa continental shelf? Or just be general? Professor Matumbakal.
Well, considering the information that it will soon be amended, we can delete it, Your Honor. And maybe we can just put in there in accordance with mining laws of the Philippines.
Yes.
So that it will cover any possibility.
Yes, thank you. So, may we ask the Nika? Hindi kayo nag-submit ng position paper, sir?
Thank you, Mr. Chair. We are finalizing, sir, our inputs. But NICA, however, will continue to provide what we have been doing to our partners.
Can we expect your submission soonest?
Yes, sir. Yes, sir. We'll do that, sir.
Before Christmas?
No, it should
Biro lang
by
ah.
next week, sir. By
Next
week.
week,
Yes,
sige. What about the Philippine Navy?
Your Honors, the Philippine Navy is very supportive of the passage of this bill because it helps us on two aspects, specifically on the issue of maritime cooperation and maritime operations. We will know now what are the resource allocations that will be given to certain areas once these maritime zone bills are approved. We are very supportive of this bill, Mr. Chair.
And your response probably would, I assume, include the Philippine rice.
Yes, Mr. Chair.
So when do you expect to have your paper?
We have not yet been requested for a
I
for a
think we
position.
did. We did.
But usually what we do is we have the Department of National Defense speak on behalf of the entire AFP and the department, Mr. Chair.
Okay. Been very helpful. We don't want to burden you too much. Malaki na ho na itulong nyo sa committee ito. Maraming salamat po. The Philippine Coast Guard.
Thank you, sir. On the part of the Philippine Coast Guard, I think we have already submitted our comments, sir. And the Philippine Coast Guard supports the passage of the Maritime Zone, sir.
Thank you. Maritime Zones Law, we will tackle in detail the archipelagic sea lanes. So isa pa yon na malapit-lapit na. Coast Guard naman lahat kayo, sir, ano? Coast Guard lahat kayo?
Yes, sir.
Thank you. The NSC?
Thank you, Mr. Chair. Thank you for inviting the NSC at the same time representing the National Task Force on the West Philippine Sea. Apologies for Secretary Anya. The National Task Force on West Philippine Sea supported the House bill that was amended, but that was presented by the Congress. And at the same time, the 10 proposed bills that we do have in.
But we have some amendments, narinig nyo naman,
Yes,
di ba?
yes,
So would the position remain the same?
We will just make the amendments and forward to you, Mr. Chair.
Kailan po sana, sir?
We will do it the soonest possible time, Mr. Chair.
Thank you.
Yes.
What about, pasensya na po, hindi ko mabasa yung...
From the Jesse Pascasio, sir, from the Department of National Defense. So, sir, from the part of the DND, we express our support for the immediate passage of this bill, and we join the other members of the executive branch in fully supporting the Senate in its task. And
how we should treat the islands constructed artificially, illegally by other states.
we will do so, Mr. Chair.
Help us navigate. Thank you. DOJ, narinig na namin, you've been of great help ever since. Maraming salamat. And Ma'am Sandra, hindi ko po mabasa na yung pasensya na kayo kung
It's okay,
kung
sir.
nagkapitan po ako ng barko, hindi ko na makita yung dinadaanan.
It's okay, Your Honor. I will submit my position paper, but then basically I support the immediate passage of this maritime zone bill, and we also support that there are three bills that are the same, and I think that the contents of those bills are general enough that will forward or maximize our sovereignty and sovereign rights over our food security. No, that's fisheries, as well as energy security and military security. So I think this should be put forward as a priority bill, Your Honor. That's all. I will submit my position paper.
Ma'am, to receive your position paper.
Yeah. Tomorrow. I will send it right after
Tomorrow?
I leave yeah, no, tonight.
Oh, ang bilis ah. Mabilis. Thank you. Thank you.
Tonight.
Alam nyo, yung,
As soon as I get the
nagtuturo
internet
ko, meron akong
connection.
3 estudyante, hindi pa nakakasubmit ng midterms na paper. Thank you, ma'am. Thank you, ma'am.
Okay.
Before we end, I'd like to recognize, pwedeng umupo dito sa may bakante pang 2 lamesa doon, upuan doon, na Maria, Department of Foreign Affairs. We have not totally excommunicated you. We would like to recognize you. Pwedeng umupo kayo doon sa the representative of DFA. Doon, 2 po yung bakante po doon po. There is always absolution in life. Siguro narinig niyo po yan. May we, under oath na kayo dati, di ba? May we get your name again? Namria, yes. DFA, having heard all of this, will we be in a better position if we pass this measure? Will we be better off? Or if we remain in the same legislative status quo, not passing this, would it lessen the tension, or would the passage of this measure agitate some powers that probably would make the functions of the DFA more difficult? So what's the position of the Department of Foreign Affairs? I'm sure you're authorized to speak in behalf of Secretary Manalo.
Sir, thank you for giving me the floor, and thank you for welcoming us back to the committee.
Paige, di kayo nagbigay ng merienda sa DFA.
Ay, meron po, sir. Okay
Meron?
lang po. Sir, I'll echo the statements of OSG Guevara that the majority of the member states already support UNCLOS. So passing a legislation that is fully aligned with UNCLOS will certainly help us advocate for being a country that supports a rules-based order. So I do think that, and we have been supportive of this whole process for more than a decade already. So I think that if we finally bring this to a conclusion, thanks to your leadership, sir, that we will be much better off. Thank you.
Because of that, you will go to heaven. When do we expect your position paper, ma'am?
Sir, I believe we gave the position paper from the previous, but with the amendments that were discussed today, we can discuss and we'll submit certainly before the next meeting so that it can be considered for the technical working group, sir.
Thank you. Salamat na rin pakiabot ang pasasalamat kay Secretary manalo. What about Namria? Namria, mention was made of charts. Any shifting position, new position? No, Namria, we already touched base with other foreign groups to get hold of the exact needs and bounds of what is under consideration. We touched base, this committee touched base with the United Nations, the National Geographic Society, just to really have a complete idea of the areas we are discussing. And we know Namria can be of great assistance, sir. So siguro yung measurement of we will need from you the exact measurement of the territorial sea, the contiguous zone, the exclusive economic zone, as mentioned in Article 47. And Namria should really be part of this group. We are not sidelining you. You will form part of the whatever would be the product and output of this committee. We recognize your good work so far, things you've done, and we hope to be continuously engaging with Namria. And I supported even your budget during that budget hearing of DNR. So again, relay to your good secretary our best wishes. So Namria, if you have a position paper to submit, kung gusto mong isekreto na lang, isil, o lagyan ng napakaraming stapler, you submit this to this committee. And for the record, may we hear something from Namria before we end?
Thank you very much, Mr. Chairman. Yeah, we have our position paper and I'll submit it afterwards. And if I may just read it.
Go ahead, sir.
The National Mapping and Resource Information Authority fully supports the various maritime Senate bills defining the maritime zones of the Philippines in accordance with the provisions of the United Nations Convention on the Law of the Sea. As the central mapping agency of the government, the NAMRIA needs a definitive legal basis for drawing the outer limits of our maritime zones. While we have Republic Act number 9522 establishing the archipelagic baselines of the main archipelago and treating the Kalayaan Island Group and Bao de Masinloc under the regime of islands consistent with Article 121 of UNCLOS, we still have to deal with the existing provision of Republic Act number 3046 on the territorial sea and internal waters of the main archipelago and the need for a clear basis and delineating the contiguous zone. We are grateful to this committee and the authors of the bills for recognizing the urgency of enacting the Maritime Zones Bill in the light of pressing developments in our maritime fronts. We therefore join our colleagues in the executive branch in supporting this vital piece of legislation. We fully agree with the provisions defining the different maritime zones and the sovereignty, sovereign rights, and jurisdiction that we exercise over them. We welcome the provision on delimitation in cases where these zones overlap with those of neighboring states, as this will facilitate our work and delimiting the common boundaries. Thank you very much, Your Honor, Mr. Chairman.
Salamat po, Namria. Again, thank you for your participation. We expect your position paper likewise. At kung meron kang sealed communication that you would like to submit to this committee, we will gladly accept. And as I've mentioned to the DFA representative, she will go to heaven. You will be beatified for helping this committee. Without objections on the part of my other colleagues, some of whom are listening virtually, I'd like to thank all of the resource persons who helped this committee and this special Senate Committee on Maritime Admiralty Zones hearing is hereby adjourned. Thank you.